This is episode 3 of a 3-part webinar series, Ethical and Other Issues in Lateral Attorney Movements. The title of this episode is The Exit and the Entry, Making the Leap Without Breaking Things. Slides 2. 2 is, as you'll see, I'm clicking the slides as I refer to them, is a little about our user response, law review. Slide 3 continues that. Slide 4 is a disclaimer reminding you that you're not our clients, we're not your is for informational, educational purposes. Slide 5, Alex. Of what the series intended. 7 list. Watch this series for CLE credit on Sarafai's Legal Edge. You can also watch it at no cost on the National Law Review YouTube channel. That's the housekeeping. So with that, I can ask my distinguished panel some questions. And let me start by taking us to slide 11. Again, this is third of 3 episodes, and we've been through a lot of material so far. Slide 11 sets out in very broad steps the lateral move process, if you will. I don't have a question about it. I just want to start with that slide for context. And with that slide displayed, let me ask us to focus on a question about missteps. How can an attorney avoid common missteps in announcing their departure to their current firm? And stay within the confines of my question, please. We're talking about announcing to their current firm. Slides 28 and 31 will be relevant. And Alex, would you take that for us?
Yeah. What I always tell the people that I represent is that you know your firm the best. You know the personalities. Presumably, you know how other people have let the firm know that they're going to be moving on. And so the most important thing is to follow the firm's procedures that are laid out either in your partnership agreement or the process documents that the firm provides you when you join the firm. So that's the first thing. And the second thing is to do what other people have done that's been successful. And in fact, I'm working with a candidate right now who gave notice actually yesterday. And so far, it's been very cordial. And I think the reason is that he's approached it from a very matter of fact and sort of non-personal position. And I think it's going quite well. So you know your firm and you know what's going to be successful.
Who wants to overlay, if anyone? Dan, the next question is going to be for you. Audience, I'm going to display slides 29 and 59. We were talking about notice to the firm. What about notice to clients? And talk to us. Let's enter this area of questioning through the specific question. What are the pros and cons of a joint notice to clients? And why don't you make sure we all understand what I mean by a joint notice to clients?
Sure. So joint notice to clients is, I would probably say, and Tina would probably agree, is the gold standard in terms of how it should happen. Whether or not that always happens that way is a different story. Sometimes it's best to suggest that. In most circumstances, there are certain jurisdictions that may require a client to notice, if it's going to be a massive impact, if there's a big litigation, to let the clients know as soon as possible. And sometimes firms will drag their feet on doing the joint notice because they want to establish ways for the firm to try to keep their hooks in the client. So that's why having ethics counsel is so important to help guide versus what your ethics obligations are. But ideally, it's shared together. In reality, it can often be a race to the phones where the partner is racing to the phones to let the client know, or the firm is racing to the phones because they want to try to keep their hooks in the client. So I would say it's kind of it is the gold standard, but in this sense, it's like a speed limit where it says drive 55, but in reality, many cars drive 65 or 70 because that's how things shake out. Um, I would say in most of my situations, it's very, it's probably more of an exception that they all get on the phone together, tell the client jointly, and the client already doesn't know about it through a heads up from the partner or through someone else because word leaks.
So what happens if the firm insists on sending the notice on behalf of the attorney, the departing attorney? What rights does the departing attorney have in that case? We'll start with slide 30's audience. And Tina, you want to take that for us?
Sure. So the departing attorney does have rights under the rules, and I would draw the audience's attention to ABA Formal Opinion 489. First of all, Dan's absolutely right in that the gold standard and best practices under ABA rules and most states' rules are try to send the letter to the clients together jointly. But I also will agree that Dan's right when it's usually a race to the phones. But if in your hypothetical, Jonathan, the firm says, no, we're going to send the notice or we're going to tell the client on your behalf, the departing attorney has the ability, and again, I would advise everybody, check with your state-specific rules for the jurisdiction that you're licensed and barred in and practicing in. But typically, once you've given the firm the opportunity to send out that joint letter with you, that is usually all that is required before that departing attorney can either send a written notice unilaterally or the departing attorney can, pick up the phone and call the clients himself or herself. So you do, as a departing attorney, have the ability to speak to the clients on your own, and the firm cannot restrict that right to do so. Moreover, if you look at some of the state's ethics opinions or opinion 489 from the ABA, it also says that prompt notice should be given to the clients. And so oftentimes the firm tries to hold off or tell the departing attorney to hold off. Again, we've got to remember the departing attorney has competing fiduciary obligations here with the client's interests being preeminent. So hopefully that answers your question, Jonathan.
If I can jump in here real quick and maybe play
Please.
Jonathan's role for just a second, because one of the things that I think is super important and is very bespoke kind of when you get in each one of these situations is, when you are the attorney and you are giving notice to a client, the language there is very important in terms of what you say. Can you talk a little bit more about the advice that you've given to all of us and attorneys that we're working with kind of in the specific language?
Sure. And so I think, are you talking, Brock, about the specific language in the letter or
Well,
what?
I think there's a difference between notice and solicitation, and at some points, folks can struggle to really understand exactly what they're able to convey to their clients.
Sure. So great clarification and great point, Brock. So let me be very clear. Before someone who is leaving a firm gives notice to the firm, there should not be any pre-resignation solicitation of clients absent exigent circumstances. And those exigent circumstances are very limited. And by an exigent circumstance, I mean you're a litigator and you are planning on defending or bringing a TRO on well, I guess it would be defending because you wouldn't be bringing a TRO on the day you're also giving notice. So in my hypothetical, you're planning on giving notice on Monday, Friday afternoon, your client gets hit with a TRO and the hearing's going to be in front of the judge on Monday. Under those circumstances, again, it would depend on the facts and you discuss it with counsel, but under those circumstances, you should, placing your client's interest first, give them a heads up and say, listen, you just got hit with this temporary restraining order. It's up. I'm planning to give notice to my firm on Monday. Let's talk about this. But absent exigent circumstances, there cannot be any solicitation of clients before you give notice to the firm. Once you give notice to the firm, then you can tell clients that you are leaving. It is still preferable after you've given notice to the firm that even if you speak to clients about the fact that you have given notice and that you will be leaving to go to another firm, I still think, and I counsel very conservatively in this regard, I still think it is better not to solicit those clients until such time as the letter has gone out, giving the client their three options. Files can stay at the current firm, files can go with the departing attorney, or the client can hire someone else. That protects the departing attorney. So I think that's the clarification you were probably hitting on, Brock, which is making certain that any conversations that you're having before that letter goes out, talk about just sticking to the facts with clients.
Tina, what if you're moving and you want to bring others with you? Audience slides 55 through 57.
So that depends on who you want to bring with you. So in most states, and again, always best, the law differs, so check with your ethics counsel. But in most states, you are able to speak to other partners about a potential move. Associates.
Can I ask a question, Tina?
Sure.
Does that include non-equity partners, contract partners?
That is a great question, Dan. And the answer is in most states, yes, it does include non-equity partners. So you can speak to equity and non-equity. So thanks for that follow-up question because we get that all of the time. Appreciate that. Now let's move to counsel, associates, staff. The general rule is that, but there is a lot of variance here. And so again, to our audience who's listening, please check with ethics counsel because the rules vary state to state in this regard. But generally speaking, if someone is not an equity partner or not an income partner, non-equity partner, you should not and cannot solicit them prior to you being released from your current firm because in many states, those individuals are considered to be assets of the firm. Now, to be certain, there's variances to that. But again, before the better course of action is to always seek guidance from ethics counsel before you're speaking to individuals. You don't want to get in trouble. And again, that's one of those bells, much like you don't want to solicit clients before you give notice. The other sort of unwritten, or I should say written rule, and most important rule is don't be soliciting non-partners once you are considering a move. So get guidance first. Don't have the conversation and then say, uh-oh, should I have done that? No, not the proper way to do it.
If an associate finds out that a partner is moving and they approach them and say, I want to go with you before they've left.
So in that situation, remember, the partner has fiduciary obligations to the firm. And that partner has to be mindful of those obligations. So obviously, partner can't stop the associate from approaching. But what the partner has to do in that situation is say, I appreciate you coming to me, but please understand I've got fiduciary obligations to the firm and I can't speak to you about this. I am prohibited from soliciting you at this point in time, but I appreciate you coming to me. No, I enjoy working with you, but we can't be having this conversation right now.
Tina,
But Tina, that doesn't mean, well, let's say the associate approaches the departing partner and the departing partner says what you just said they should say. If the associate knows where the departing partner is going, nothing prevents the associate from contacting the new firm or the new firm contacting the associate directly. True or false?
True. That is absolutely true. But again, the departing partner cannot be involved in that process.
Tina, this is a really important topic. I'm curious, do you ever have situations where the partner will refer the associate to the recruiter that they're working with and say, please reach out to this person? Can you walk us through that scenario? Because it's something I've encountered in my travels.
Sure. I mean, I will tell you that when I say the partner should not in any way be involved in that process, um, that also means shouldn't be referring, right? Because it could be direct or indirect solicitation. However, again, to John's point, there is nothing that prohibits an associate from reaching out to a recruiter or reaching out to, a firm if they have learned where the partner is going. And let's be very realistic here. As much as partners try, I mean, oftentimes once they give notice, the firm may say, don't say anything. But news travels like wildfire. It just does. Inevitably someone leaks it. And so there's nothing that prohibits the associates from reaching out if they know, if there's a recruiter that they like to work with, or if they happen to know if a partner is working with that recruiter. I'm not going to say it doesn't happen because we all know that sometimes it does. But the point being for the departing attorney, he cannot be involved in that process in order to adhere to the fiduciary obligations that are owed to the current firm.
Let me change direction a little bit. Let's talk about, we've been focused on our communications with our current firm, the firm from which we're departing. Now let's look at the conversations we're going to have with the potential firm that we're talking with, maybe moving to. And audience, in the context of that, slides 13, adhering to multiple duties, and slide 76, confidentiality of information, are pretty applicable. Let's talk about not the substance of the matter, but just the identity of the clients. So if a partner is interviewing with firm X and firm X says, well, we need to figure out, not only if we want to make you an offer, but how much and all the details. how much can the interviewing partner reveal about their client base and their revenue history while still while not running afoul of the rules? Tino, you want to start us off?
Sure. So with regard, again, I'm going to sound like a broken record, and I apologize in advance to our audience, but the rules vary. There's a nuance in DC on this, for example, that Mr. Binstock and I dealt with a while ago. So again, check your local jurisdictions. But generally speaking, you can divulge the names of clients during the interview process. However, divulging the names of clients is very, very different from talking about the substance of matters. And this is where Rule 1.6 comes in. So let me throw out a couple of hypotheticals. Let's say, for example, that you're an M&A attorney and you're working on some, confidential M&A deal that is not publicized yet. You better make certain that you are not disclosing any of the details of that confidential project in your interview. Same for, I'll flip it to a litigator. If you have a client that is thinking about suing someone for whatever the reason is, you can't be telling firms that you're interviewing with about the fact that that client, we may be engaged in a really big lawsuit in the next 2 months, whatever it is. You have to be very, very careful. So I think Jonathan's point is well taken in that it's one thing to be talking about the name of the client versus the matter that the clients are involved in. And in terms of revenue history, and then I'll let others weigh in on this because I know this is an important topic. But in terms of the revenue history, I view revenue history, and I think this is consistent with the rules, as part of that attorney's own information. Certainly, you shouldn't be using the entire firm's Department of Revenue or discussing anything like that during the interview process. But in terms of your origination or the origination that, you have done historically, I don't view that as firm confidential information. I view that as the individual's own information, much like his or her compensation info, which clearly, if he or she wants to share, he or she is entitled to share.
It seems to me that, if I said, well, my originations were X million dollars last year, fine. And I continued, and that represented 50% of my firm's overall revenue. That would be a bad detail to include.
Yeah, yes. The second part of that sentence, I would shy away from.
Yeah.
Even if, because we know sometimes, firms disclose their total revenue and there's all sorts of different blogs and chats and things out there. But in an abundance of caution, because again, I counsel very conservatively. Yes, Jonathan, I would not advise including that second part of the sentence during the interview process.
The real tension, if I can just add here, is that a lot of law firm questionnaires are pretty aggressive in what they ask. We see a number of them that will say they'll give a big chart, clients, how much did you bill this year? What was your collection percentage from them? What were your discount? What was your standard rate? What was the actual rate that you billed to this client? So there's a lot of not only confidential, but competitive information. They say, oh my gosh, this firm's able to charge, or this firm's discounting this client, so so much that firms ask in their LPQs that I wonder, I wonder how much of that could be used in some way that's beyond just simply evaluating the partner, but gathering competitive information. That question being aside for a very different conversation on a different day, it's very hard for a partner that really wants to join a firm to say, hey, I think what you're asking for is overreaching and improper under the rules, so I'm refusing to answer this. And it puts the partner in a very difficult situation because a very or disclose too much, and it's a tough situation.
You raise a good point, Dan. And one of the dialogues that I've had with several of my good law firm clients is, look, there's a time and a place to ask these questions. So it's really important that these questions get asked from a conflicts perspective, but maybe we can move it later in the process. And one of the law firm leaders that I was talking to said, well, we just sort of need to collect this information, up front. And this was very early on in this particular candidate's process. And I said, to be honest, how would you feel about another firm asking your partners the same question at this point in the process? And he goes, well, I take your point. And so, and I think there has to be a dialogue and a give and take between the candidate, the recruiter, outside counsel, and whichever firm you're dealing with about, okay, when is it really appropriate to reveal particular information, and when is it necessary? And it's always going to be a give and take.
Okay, so go ahead, Tina.
I was going to say, I think that's right. And I would certainly, ask the three of you, but I am seeing more phased approaches here. And what I mean by that is, maybe someone has the first couple of interviews and then we're filling out the more detailed information in the LPQ. I'm seeing some firms say, all I need right now is sort of this section for the LPQ to get started. And then if the process progresses further, then we'll need some of the more detailed and sensitive information. I think Dan's right. I think it's a real fine line that candidates walk, and I think it's difficult. And I think Alex is right too. I think there's a time and place for everything. So I don't know what you all are seeing, but I am starting to see some more flexibility from the firms than there used to be in the past in terms of saying, no, you must fill this out at the forefront and then we'll move forward. I'm starting to see firms being a little bit more flexible in terms of exactly when they need that information.
Yeah. I think it also is on the recruiter when there's an ask for too much information too soon. I think that a good recruiter should know what's market and what other firms are asking for, particularly if it's in for the same attorney or group. And so they should really be able to play defense on that. Last week was on a deal that I was working on, had a firm basically asked for like 3 years of trailing revenues and major clients before even setting up a screener. Just said, come on, guys, like this is not reasonable.
Yeah.
And I have in my career, I was not involved in this process, but I have spoken with more than one candidate who felt like a firm that they had sort of given a lot of information to early on. Another thing we haven't spoken about is when they ask for client references. Sometimes most candidates who are smart about this will wait and kind of give that information toward the end. But I have heard of instances where, and hard to confirm, but I've heard of instances where it feels like to a candidate that a firm may have used that information and then quickly on the heels of that gone and contacted folks at clients to try to usurp them. So I think you do really want to be careful about who you disclose what to and at what point in the process. The other thing that I think is an important distinction to make here is in the LPQs and in a lot of LPQs, you'll see the conflict section in the LPQ itself. To me, best practices are that conflicts is run by an entirely separate team, the working group of the attorneys who are handling for the firm lateral recruiting should not be getting the conflicts form. That, of course, has much more detailed and confidential information, and that should be purely for the conflicts team. So I've been asked before by candidates, hey, should we be concerned about the confidentiality of what I'm putting with the detail here in the conflicts form? And we're always careful to make sure that that's being handled entirely separately and it's not being sent over with the rest of the LPQ to the same team.
Did I understand you earlier to suggest that you had a candidate who was interviewing at a firm and the firm tried to steal the client based on the attorney saying, yeah, here's my list of clients?
That was their suspicion. I was not involved in that process, but I worked with the candidate subsequently.
I have also run into that same exact situation. I've heard about it a couple times, again, not for people that I represent, but people that come to me subsequently. And it tends to happen in small bars where, there's a lot of competition for a small amount of work. And I've seen it, and I think as Brock pointed out, it's a good recruiter's responsibility to help protect that information, because it is quite sensitive.
I'd say it's a good recruiter's responsibility to blackball that firm and refuse to send candidates to it.
Yeah. In my case, it was a firm that was on the smaller side, who I have not worked with before. So, I certainly noted that away. But agreed, it's, a terrible breach. And it's something that I think is very, very rare among kind of large and sophisticated law firms, but it is something that is out there.
It reminds me what I always tell clients about negotiating NDAs, non-disclosure agreements, and you could have the strongest NDA, but the last thing you want to do is actually sue on one. And it's what we're talking about is basically phase diligence, which is appropriate in this context. It's appropriate in any M&A context. You don't give the secret recipe until like every other contingency is clear. Right? It's the day of closing where you reveal your two most critical clients and let the buyer customers let the buyer talk to them, kind of thing. Okay, so we spent the last few minutes talking about a few of the things that lateral lawyers looking to make a lateral move should probably not do during interviews or during information sharing. What other common mistakes do attorneys make in lateral interviews? Audience, gonna look at slides 41 and 42, and these are misreferences. These are not relevant slides. Forget what I said. Just talk to me about the question. Brock, what do you see? What have you heard about, and what have you observed in terms of lawyers making just mistakes while they're interviewing?
So this is a fun one, and I'm sure everybody's going to have a lot to talk about here. And I may interpret this broadly when you say when you talk about attorneys making mistakes, I'll interpret it on both sides, because I think there are good lessons both for a candidate and for the interview team at a law firm. So, kind of the principle of a really successful interview, in my opinion, is identifying synergies between the two sides where you can make 1 + 1 = 3. And so in my mind, that's kind of the guiding light that both sides should be approaching these meetings. How can we identify a synergy where by coming together, we can really do something special? So against that backdrop, things that I have seen that sort of make it harder to do that on both sides. Number one, I think it's just being really prepared on both sides. That means, when you're the law firm, having making sure that the interview team has reviewed in detail the candidate's information, they know about the person's practice, and really a lot of the subtleties, is as much as they can kind of go below the surface in their preparation and in the initial discussion, I think on both sides is super helpful. So, understanding where you've got client and practice synergies, really kind of ahead of time, trying to get a good sense of where the strategic benefits could be of joining up, and then being really prepared to kind of jump in and focus on that. So, mistakes, I think just focusing too much on yourself, your accolades on either side. If the firm talks too much about their accolades, their history, things that they have done, I think they sometimes lose great candidates. Same thing on the candidate side. I think it's really important that the way you present yourself in a meeting, I mean, more and more these things take place over Zoom. And so I think, being dressed, it's crazy, I have to say this, but at all levels, I mean, being dressed appropriately, not multitasking, that's one of the biggest complaints that I've heard from senior partners all the way down to associates, is that they get on and somebody on either side is multitasking. And of course, you get that there are emergencies, but trying to minimize that. And then again, just being really prepared, understanding the background, and showing everyone on all sides that you really want to be there. And then the last thing, this is kind of, and I know that there are a lot more, but I'll let everybody else weigh in too. The last thing for me that I think is a big issue on both sides, and again, this is for lawyers at all levels, I think focusing on compensation too early before you actually have the discussions about the nuts and bolts of the practice is a real mistake. And I've had two instances of different lawyers in different practices and different levels who are entering processes over the past month or so. I've had two instances where they have been so focused on how much are you going to pay me, like before they're even getting into the room. And I understand why people in many cases care about that, but you have to put the right things first. And focusing on money too early really turns people off on either side.
Let me ask a follow-up question about that. So let's say a lateral partner, and I'm thinking not every lateral lawyer looking to make a move uses a legal recruiter. And we talked in prior episodes of all the reasons why an attorney should consider using a legal recruiter. And I'm just spitballing, but I would think that if I'm at a firm and I'm making X dollars, and I know for sure I don't want to take a pay cut, utilizing the legal recruiter as a a sifter to sort of ask that just to make sure on the very front end that we're just not wasting each other's time. Not that we need to get into the nitty-gritty of exactly how much it would be, but just to know that we're talking in the same neighborhood. What do you think about that? Is that a good use of a recruiter?
Certainly. And I think that's a very appropriate conversation to have, recruiter or not. However, where it becomes an issue, you literally see candidates who want to know, they don't want to know a neighborhood, they want to know what their number is going to be. And, I was talking to a chair about this last week, and they said, look, would I be doing my job if before I get an LPQ, before I understand the cultural fit, before we really have, gotten into this in detail, would I be doing my job if I was to say to someone before all of that stuff, yeah, that number should work for us. Absolutely not. So it's about protecting a partnership, both from a financial perspective and from a cultural perspective. So some candidates will push really, really hard. And maybe this is recency bias for me because I've dealt with it twice in the last month. But certainly some understanding of, are we in the right neighborhood, or this is where I currently am, I think is very fair early on. But you can't negotiate the whole comp package before the first meeting.
One thing I'll add on this topic in particular is that it's important for the attorney going into the interview and the recruiter to have a good sense of who within the firm is responsible for what during the recruiting process. There are some firms that will, at only a specific level of seniority in the firm will those people be authorized to discuss compensation. There are certain people in the firm, like the practice group leader, that are more suited to discuss the logistics of the practice, or associate staffing. I mean, little logistical details. So it's really important when you're thinking about how do you prepare for an interview and what mistakes to avoid, to make sure that you understand the role of the person that you're speaking with and why they're speaking with you. In some cases, it might be that the person you're speaking with is just the person that recruiting was able to put into that meeting on that particular day, and doesn't have a tremendous amount of information about the practice that you're joining, and is just a critical mass of partners that you need to speak with. So I think it's really important to understand the context, and a good recruiter will know why each person is on your panel, and they'll understand what the role of each interviewer is in that process.
If I'm a candidate, I'm interviewing with a firm, what red flags might I want to look for during the interview process? Alex.
The biggest red flag I tell people to look out for is that when you ask a question, you receive very different answers from different people, depending on who you're speaking with. Everyone at the firm that is interviewing you, and I always tell candidates at the partner level, it's a two-way street. You're interviewing them just as much as they're interviewing you. It's very different from associate recruiting. And if the answers are not consistent, or there seems to be disagreement internally on the answers very clearly, that's a huge red flag for me.
That too is a two-way street, because I can tell you, I remember so often, if a bunch of us are interviewing a candidate, and then when we come to compare notes, and we're like, the candidate told me X. Well, the candidate
Right.
told me negative
Right.
X.
The
The candidate
messaging
told me
should be
why.
consistent on both sides.
Yeah.
The other thing that I tell people to watch out for is that, absent the answers that a law firm will give, or the technical on paper reasons why you might be particularly interested in joining a firm, the vibe, there's no other way to put it, the vibe is really important. You're joining a partnership. You're entering into a not only contractual obligation, but a contractual, relationship, but also a business relationship that is going to be deep and hopefully personal with these people. And so if you do not see yourself, sitting next to these people on an 18-hour flight, across the world, you're going to have a problem.
Yeah.
I
Go ahead, Dan.
One other thing that lateral partners, I think it depends. There's certain lateral partners who really understand. They understand the interviewing process because they've moved before. And then there are other people who've been lifers. They've never interviewed as a partner. And then they start interviewing as a partner as if they are still an associate, or they go back to what they thought is the right way to, and they need to really understand that it's not an interview, it's a conversation. And there's no right or wrong answer. And it's okay to say, my book of business, I don't know. Here's what I've done each of these past couple of years. These are what the numbers look like. If I were to move right now, here's my best guess, low, medium, and high. But these are the other factors that could get in the way. There's another partner here that's really possessive of this. That could really bump down. So being very honest about really the likelihood of certain things coming and also the obstacles in the way of certain clients coming, a firm is going to take much better to that than if you come in and say, oh yeah, I've got a, 10, $11 million book of business, and you're just like, and you're coming from a firm that's known for having massive institutional clients. And also understanding that certain firms consider credit very differently. Your origination credit at your firm, if they double or triple count numbers, is going to be very different in terms of what your credit's going to be at your new firm. So taking that time to say, how do you all treat credit? How do you count origination? So the more curiosity you have in asking questions, it's going to engender a lot more trust in the answers that you actually give, because it's going to signal that you're taking time to understand the question, not just be so eager to answer it. And a lot of partners at the interviewing firms don't know how to interview either. So sometimes it's a little bit more incumbent on you to have to educate them the right way. And that's where having a recruiter can help you make sure that the questions you're answering and how you're answering them is going to result in the best messaging coming through in the most accurate way.
Another thing that, in my experience, firms vary a great deal in terms of how good or not good they are at it is once the person has made an offer, the person starts, how is the person integrated into the firm? What's the integration process look like?
Huge, huge.
So talk to us a little bit about that, Dan. What are the hallmarks of a well-run lateral integration process?
Yeah, so it varies so widely, but the questions partners should ask is, what is your process for integrating partners? Is there a formal process in place? Who are the different people? If I were to start today, who would I go to for logistic things? Who would I go to for cross-selling? Who would be sort of my guide during this process? With other partners that have joined, give me examples of people that have done well. Give me examples of people that didn't do well. What is the difference of those different types of situations? So if a firm just kind of, you feel like you're going to get their computer, phone, and it's sort of like fend for yourself, and they don't have a process in place that's, a good firm will give you a document, say, we're going to have you meet with our integration specialist who their whole job is helping people integrate. That's great. Some other firms say it's going to be the practice leader, but the practice leader is probably really busy and may not have the time, and you don't want to be knocking on their door constantly. So really asking them, what would these next 6 to 12 to 18 months look like in terms of integration, and what is the firm's process is such an important, I'm so glad you brought that up, because it's such an important message or question and topic to discuss.
I would imagine that the integration the integration process is going to vary from firm to firm tremendously. Um, and this is sort of related, but maybe it's also non sequitur. In my view, pick any 300 to 1,200 lawyer firm, and some of those firms are highly, let's talk about the word integrated, but not in the context of lateral recruiting. Let's just talk about the way the lawyers in the firm practice with each other. If you've got, a national group, the bankruptcy group, the IP group, the employment group, a firm that has nationally integrated or internationally integrated practices that have matters that are large enough to, require 10, 20, 30 or more attorneys, they're fundamentally built differently than the kind, you could have a 600 lawyer firm, but the way it operates is exactly the way a 100 lawyer firm or a 50 lawyer firm would operate, and kind of in very discrete um, clusters, not integrated with each other.
They're firms within firms.
Yeah. I don't know if I have a point. I just felt like saying.
Well,
oh, sorry,
I think that
go figure.
Jonathan, a lot of this I think comes down to there are some practices that are more self-contained than others, and I think that a lot of integration, much of it is work that should be done during the lateral interview process, and really what that is about is building relationships with the colleagues who you expect to be working with on day one. So I think one of the most important things you can do during the process of interviewing and looking at multiple firms is really understanding, and let's say you're an M&A lawyer, you want to understand who the acquisition finance lawyers are that you'll be working with. You want to meet the tax lawyers, the exec comp lawyers, everybody who will have an impact and play a role with respect to a practice that you may be bringing. So I think a lot of firms that do integration really great do a lot of that work just in making sure that relationships are built ahead of time, and that these relationships are both, built on talking about the substance, but also trying to get people socially comfortable with one another. Another thing too about integration is just being, and again, kind of during the lateral process, being very open about what policies and procedures and kind of the norms are with respect to things like business development, understanding budgets, really understanding what the culture is of a particular firm with respect to BD, which is one of the most important administrative functions, but all of the others as well. And again, I think a lot of that work should be done actually before the person has their boots on the ground at a new firm.
Brock, what's the best way to for an attorney who's interviewing to ensure that the things they hear during the interview about how life is going to be, how those expectations that are set during the interview process actually match the reality of the firm?
Yeah. So, I think there's a couple of points here. First of all, and I think Dan I think mentioned this on a previous podcast, but things with respect to offers and economics, you want to make sure that everything that has been, what was that quote you gave, Dan? It was really great. It's like,
the softest writing
Yes.
is stronger than the loudest yelling.
Yeah. So from an economic perspective, I mean, item one is just to make sure that everything you've discussed that relates to the nuts and bolts of your offer and your employment is actually written. So that's that. With respect to getting a sense for, is the culture and the opportunity and the practice, like I'm hearing it is, a tremendous resource is recent laterals. And when you are interviewing with a firm, they should be very willing to connect you for candid conversations with recent laterals to talk about what their experience has been like. I think that, for savvy candidates with good recruiters, this is an opportunity sometimes to do a little bit of reference checking on your own. You can talk to alums of a firm. You can talk to people who are, close friends of a firm, or who may have really good market intel that is kind of outside of the folks who may be put on an interview slate. But I think that really, at the end of the day, it's always a little bit of a leap of faith, and doing as much diligence as possible is the way that you mitigate any potential risks. And being really emboldened to ask the tough questions, especially as you get further into a process or starting to narrow down potential firm suitors. Doing that diligence, working with your recruiter to understand what are the right questions to ask, really focusing on recent laterals, both success stories and understanding where laterals have been unsuccessful, why that may be. And then I think really getting a good sense for leadership and department heads and learning as much as you can about the way they tick, both from them and from others, helps you to kind of do that diligence and get more comfortable.
You're on mute, Jonathan.
Thank you. What kind of diligence will a firm do on the candidate? I mean, outside of the four corners of the LPQ? They do background check?
I'm sorry, Alex, go ahead.
Outside of a standard criminal background check, I've seen a number of interesting types of diligence that firms have started to do actually more recently. Some of them involve reading public filings that you might be involved in. Some have even hired what I would call corporate intelligence firms to look at your LinkedIn and see people that you interact with frequently and call those people and ask people in industry about you. And in one case, I actually had a candidate say that a friend of theirs had received a call, it was a law school friend of theirs, had received a call about them from the firm. And I said, well, that's really interesting. What's your reaction to this? And he said, well, the firm was really smart. They said that they were thinking about hiring me for a project and they wanted a reference to see if I was any good. Now, I could see a situation in which that would make people uncomfortable. I can also see a situation in which, if done improperly or without care, that can create serious issues for the lateral partner. But I think that firms, because there is such a high cost of having an unsuccessful lateral, they're doing more due diligence in recent memory than I've seen. I think part of it also comes, and I'm sure others have opinions on this. During the pandemic, there was a boom of lateral hiring, and I think that now firms are being very cautious and a little bit more conservative about the laterals that they hire.
Yeah, and if I could just piggyback on that, Alex, about the corporate intelligence, another way they call it is reputation checks. And the law firms in the background documents where you think you're just signing basically like the normal things, you're confirming your employment, things like that, they'll have a sentence in there saying you authorize us to employ a third-party reputational check company to do reputational check on you. Most people never notice that. But what they can do is call another company that can then, as you were saying, Alex, they can start calling people. They can call your 5 competitors and say, we're looking into, what do you know about each 5 of these people? And tell us whatever it is. And then if these companies say that the people are experts on doing their former FBI agent or whatever it is, but I've gotten calls from people that say, I know someone's looking because one of these reputation companies called and it was so obvious that they were zeroing in on this person. And it can unintentionally out people. So we understand that firms want to do their due diligence. Sometimes there are things that they don't know unless they speak to other people. But partners should realize if they're agreeing to a reputational check or something like that, or corporate intelligence or something like that, they should ask the firm exactly what is being done in that regard. Not out of paranoia, but just say, I want to just make sure I'm understanding what's being done in the market about my name so that I'm doing everything I can to make sure things are kept confidential.
Do any of you all know if have you worked with firms that typically do a personality inventory, personality test?
Very rare.
Not at the partner level. I've
Yeah.
seen firms do it for associates.
I think there was a period where it was maybe getting more popular, and I feel like it's perhaps getting less popular because there was quite a bit of blowback from associates who felt uncomfortable with it.
Yeah, it's about as popular as behavioral interviewing questions.
I have several clients who, for their C-suites, they use them religiously.
Well, one of the things that I often tell partners to think about when discussing these topics is you have a book of business. You are brokering your business. And so presumably you have some personality traits that make you able to get that business. And so that's important to highlight those. And I think that's why you don't see it a lot.
Okay. Well, it is 1 o'clock in Chicago, which means we're kind of done. We're out of time. Thank you. Thanks for your time, audience. On behalf of the panel, we hope that you learned something, maybe a couple things. Thank you.
Yeah.
Panel, thank you.
Thank you, Jonathan. And